Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host Aaron. Today we're discussing an important topic, the limitations of mandamus lawsuits.
We've spent previous episodes explaining what mandamus can do and how effective it can be. But it's equally important to understand what mandamus cannot do. Setting realistic expectations helps applicants make informed decisions about whether litigation is right for their situation.
So this episode is about managing expectations.
Exactly. Mandamus is a powerful tool, but it's not a magic wand. Understanding its boundaries helps you evaluate your options clearly and avoid disappointment if the outcome isn't what you hoped for.
Let's start with the most fundamental limitation. What can't mandamus do?
The most important thing to understand is that a mandamus lawsuit cannot guarantee approval of your immigration application. It can only compel the agency to make a decision. That decision could be an approval, a denial, or a request for additional evidence.
So you could file a lawsuit, win, and still have your application denied?
Yes, the court orders the agency to adjudicate, to do its job and decide the case. The court does not order the agency to approve. If you don't meet the eligibility requirements for the immigration benefit you're seeking, the agency will deny your application, regardless of whether there's a pending lawsuit.
Why can't the court just order approval?
Because that would exceed the court's role. The agency has the expertise and statutory authority to evaluate immigration applications. The court's job in a mandamus case is to ensure the agency performs its duty to decide, not to substitute its judgment for the agency's on the merits of the application.
What about the underlying requirements for immigration benefits?
Mandamus cannot change the eligibility requirements established by statute and regulation. If the law requires certain qualifications for a green card, citizenship, or visa, those requirements remain the same whether or not you file a lawsuit.
Can you give an example?
Sure. Suppose someone applies for naturalization but doesn't meet the continuous residence requirement. Filing a mandamus lawsuit won't waive that requirement. The lawsuit might get USCIS to finally review the application, but the review will still apply the same legal standards. If the applicant doesn't qualify, they don't qualify.
So mandamus addresses the timing of the decision, not the substance.
Exactly. It's a remedy for delay, not a remedy for ineligibility. If your case has a substantive weakness, litigation won't fix that weakness. It will just result in a faster decision that might not be favorable.
What about agency discretion?
Mandamus is generally not available to challenge discretionary decisions. It only applies when the agency has a clear, non-discretionary duty to act. If the agency has discretion over whether to grant a benefit, mandamus typically cannot compel a particular exercise of that discretion.
How does this apply in immigration cases?
Many immigration benefits involve some discretionary component. Adjustment of status, for example, requires that the applicant merit a favorable exercise of discretion, even if they meet the basic eligibility requirements. A mandamus lawsuit can compel USCIS to make a decision on the adjustment application, but it cannot compel USCIS to exercise discretion favorably.
What if you disagree with how discretion was exercised?
That's a different type of legal challenge, potentially an appeal or a lawsuit challenging the denial as arbitrary or an abuse of discretion. But that's separate from mandamus, which addresses the failure to act at all. Mandamus gets you a decision. Challenging an unfavorable decision requires different legal theories.
What about people waiting for visa numbers to become available?
This is an important limitation. Mandamus cannot speed up visa bulletin backlogs or make a visa number available sooner. If you're in a preference category with a long wait, certain family-based or employment-based categories can have waits of many years. Mandamus doesn't help with that.
Why not?
Because the delay isn't caused by agency inaction. The agency can't approve an adjustment of status or issue an immigrant visa until a visa number is available under the statutory limits. Congress sets numerical caps on immigrant visas each year, and when demand exceeds supply, people wait in line based on their priority date.
So if someone is waiting for a visa number, that's not an unreasonable delay the court can fix?
Correct. The agency isn't failing to act. It's legally prohibited from acting until a visa number is available. Mandamus addresses situations where the agency could decide but hasn't. It doesn't address situations where the agency is legally constrained from deciding.
What about background checks and security clearances?
This is nuanced. Mandamus cannot simply bypass or eliminate security check requirements. If a background check is a legitimate part of the adjudication process, the agency is entitled to complete it before making a decision.
So security checks are always a valid defense for the government?
Not always. And this is where it gets complicated. A pending security check can explain some delay, but it doesn't justify indefinite delay. Courts have found delays unreasonable even when security checks were pending, particularly when those checks have taken years with no apparent progress or explanation.
How do courts handle this?
Courts balance the government's legitimate interest in conducting security vetting against the applicant's right to a timely decision. A background check that takes a few months is different from one that has been pending for 5 years with no end in sight. At some point, the delay becomes unreasonable, regardless of the security check justification.
What about cases involving U.S. consulates abroad?
This is one of the most significant limitations. The doctrine of consular nonreviewability substantially limits federal court power over visa decisions made by consular officers at U.S. embassies and consulates.
What does that mean practically?
Consular officers have broad authority over visa adjudications, and courts have traditionally been reluctant to second-guess their decisions. If a consular officer denies a visa, that denial is generally not reviewable in federal court. The applicant usually cannot sue to overturn it.
Does that mean Mandamus never works for consular cases?
Not exactly. There's a distinction between challenging a visa denial and challenging a failure to act. Some courts have entertained mandamus claims where the consulate has simply failed to adjudicate a visa application at all, where the case has been sitting in administrative processing indefinitely with no decision. But the legal landscape is more complicated and less favorable than for USCIS delay cases.
So consular cases require careful evaluation.
Yes, if your case involves a U.S. consulate, you need an attorney who understands the consular non-reviewability doctrine and the specific case law in your jurisdiction. The limitations are more significant than for domestic USCIS delays.
What about compensation for harm caused by the delay?
Mandamus cannot recover monetary damages for the harm you've suffered due to the delay. If you lost a job, missed career opportunities, or experienced financial hardship because of years of waiting, a mandamus lawsuit doesn't compensate you for those losses.
Why not?
Mandamus is an equitable remedy. It compels action. It's not a damages remedy. The relief is prospective. Make a decision now. It doesn't provide backward-looking compensation for harm already suffered.
Are there any ways to recover damages?
Potentially through other legal theories, but they're difficult. The Federal Tort Claims Act and other statutes have significant limitations on suits against the government. As a practical matter, most immigration applicants do not recover monetary damages for processing delays. The realistic goal is getting a decision, not financial compensation.
If the court rules in your favor, does it set a specific deadline for the agency?
The court may order the agency to act within a specified time frame, 30 days, 60 days, 90 days. But there's no guarantee of what that time frame will be, and courts have discretion in setting it. Some courts order relatively short deadlines. Others give the agency more time.
What if the agency doesn't meet the deadline?
The applicant could seek enforcement through contempt proceedings, but this adds more litigation and more time. In practice, agencies generally comply with court orders, but the process isn't instantaneous, and the timeline isn't entirely within the applicant's control.
So even winning doesn't mean immediate resolution.
Right. Winning means the court has ordered the agency to act, which is significant, but there's still a process between the court order and the actual decision on your immigration application. Mandamus creates accountability and a deadline, but it's not a same-day solution.
Can mandamus address problems with immigration law itself?
No, mandamus cannot change immigration statutes or regulations. If you believe the law is unfair, outdated, or poorly designed, that's a matter for Congress, not the courts. Mandamus works within the existing legal framework. It doesn't reform that framework.
What if the delay is caused by a bad policy rather than simple inaction?
That depends on the nature of the policy. If an agency policy violates the statute or the Constitution, there might be grounds to challenge it. But that's a different type of lawsuit than mandamus. Mandamus addresses the duty to decide. Policy challenges address the legality of how the agency operates.
So mandamus is a narrow remedy.
It is. It's powerful for what it does, compelling agency action, but it's not a general-purpose tool for fixing everything wrong with the immigration system. Understanding its scope helps you use it appropriately.
What if the applicant contributed to the delay?
If the delay is attributable to the applicant rather than the agency, mandamus is unlikely to succeed. For example, if USCIS sent a request for evidence and the applicant never responded, the delay isn't the agency's fault. If the applicant missed an interview or failed to provide required documents, the agency isn't the cause of the holdup.
How does this affect the case?
Courts look at the full picture. If the record shows the applicant caused or contributed to the delay, the government will raise that as a defense, and courts are likely to find the delay reasonable, or at least not attributable to agency inaction.
So applicants need to have done their part.
Yes, before filing a mandamus lawsuit, make sure your application is complete, you've responded to any agency requests, and you've done everything required on your end. You can't compel the agency to act if you haven't fulfilled your own obligations.
Why is it so important to understand these limitations?
Several reasons. First, it helps you make an informed decision about whether mandamus is right for your situation. If your problem is visa bulletin backlog or a discretionary denial, mandamus isn't the answer, and you shouldn't spend time and money pursuing it.
What else?
Second, it helps you set realistic expectations. If you go into litigation expecting guaranteed approval or financial compensation, you'll be disappointed. If you understand that the goal is compelling a decision, whatever that decision may be, you can evaluate whether that outcome is valuable to you.
Any other reasons?
Third, it helps you have productive conversations with attorneys. When you understand what mandamus can and cannot do, you can ask better questions and evaluate legal advice more effectively. You become a more informed participant in your own case.
Given all these limitations, when is mandamus still valuable?
When your core problem is agency inaction. If you have a complete application, you meet the eligibility requirements, and the agency has simply failed to decide your case for an extended period, mandamus addresses that problem directly. You're not asking for special treatment. You're asking the agency to do its job.
What's the value, even if approval isn't guaranteed?
Certainty. Many applicants have been waiting years in limbo, unable to plan their lives because they don't know if they'll be approved or denied. Even if the outcome might be unfavorable, knowing the answer has value. You can make decisions, pursue alternatives, move forward. Indefinite uncertainty is often worse than an unfavorable decision.
So it's about ending the waiting.
Yes, mandamus gives you a path out of limbo. It may not guarantee the outcome you want, but it guarantees an outcome. And that's often exactly what applicants need after years of waiting with no end in sight.
Let's summarize the key points from this episode.
First, a mandamus lawsuit cannot guarantee approval of your immigration application. It compels the agency to make a decision, but that decision could be approval, denial, or a request for evidence. The court orders adjudication, not a favorable outcome. Mandamus also cannot change eligibility requirements, overcome discretionary denials, or fix substantive weaknesses in your case.
Second, mandamus cannot address delays caused by visa bulletin backlogs, entirely bypass security check requirements, or overcome the doctrine of consular non-reviewability in consular cases. It cannot recover monetary damages for harm suffered during the delay, and it cannot change immigration law or policy. These structural limitations define the boundaries of what mandamus can accomplish.
Third, understanding these limitations helps applicants make informed decisions, set realistic expectations, and have productive conversations with attorneys. Despite the limitations, mandamus remains valuable when the core problem is agency inaction on a complete application. It provides a path out of indefinite uncertainty and compels the agency to finally decide, which is often exactly what applicants need after extended delays.
Thank you for listening to the Mandamus Lawyers Podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.